Everybody, this is the South Coast Air Quality Management District Hearing Board. Do I need to redo that? Good morning, everybody. This is the South Coast Air Quality Management District Hearing Board. Today is Thursday, January 11th, 2024. Today we have two items on the agenda. However, they have gone to consent. So we have the first one of Torrance Refining Company, LLC 6060-20, and we have Colton Power LP 6167-4. So let's go through Torrance first. And what we have before us is the actual stipulation to place the petition for the short variance and the alternative operating condition on consent. And so that will be exhibit number 1. Then we have the declaration of Valerie Say in support of Torrance Refining, and that's number 2. And then we have the proposed findings and decision and order granting the short variance and the alternative operating conditions. That'll be number 3. And those are the only exhibits that we have for this case, correct, Madam Clerk? Yes, okay.
There was a email was attached from Mr. McDonough. It was part of the attachment.
For Torrance?
From Torrance, yeah.
And that's not the one you gave us earlier, is that right?
No. I think somebody was called in as Exhibit 3, but
And it's not attached to anything here.
yeah, I think it's Exhibit 3 that was referred to in the petition. Don't have that?
Nor do I.
It was in the pack. Was dated December 15th. It's from him to the clerk of the board.
All right, so that's the only one?
And this was the reference to the ex parte emergency, you know.
Okay. So we can mark that if you want to give the clerk a copy of that. I guess, Mr. Balgapon, did it come with the document?
Yes,
For the, request for consent calendar?
no, it came earlier when we got the package, you know.
I don't have anything behind number 3, and I don't have anything behind number 2. Well,
Let me see where he referred to it, Exhibit 3.
well, okay, so you're going to get a copy for us, Madam Clerk? Okay, so we'll call that HB-1.
It's not HP. It's
We'll put it's an actual
from Mr.
exhibit.
McDonough. Yeah, it's Exhibit 3.
I don't have that at all.
No?
Right, that's the
Before then, yeah,
proposed.
sorry, yeah. I think he called it Exhibit 3, you know.
Okay, so that's going to be number 4 then. Correct?
Yes.
Coming from McDonough.
Mhm.
Well, if it's an email and it's coming from them, that should be 1 because it's coming from them. I'm sorry, A. A is an apple. Because it's not coming from the district.
No, it's not from the district.
Okay, so it's coming from Torrance, so that should be Exhibit A as an apple.
But yeah. Yes, it was referenced in the, I'm trying to find that.
Yeah, I don't see it, and I didn't see it referred to either.
The exhibit, Madam Chair, the exhibit dated January 9th, 2024 at 5:06 PM from Mr. Balak Apalan on the communication. This should be HB, what is that
No,
number?
that's for Colton Power, so that's different. That's separate.
Okay. fair
Yeah, I
enough.
have that one. But I don't have anything from Torrance.
So do we want to take a recess until the?
Yeah,
clerk-
let's just
Okay.
give Al Teresa 5 minutes. We're off the clock for 5 minutes.
Yeah, it was a part of the, yeah, I mean,
Yeah. Go ahead, Makai, go ahead.
Yeah, so my argument around the exhibits and the discussion therein, once we receive any communication forwarded to the hearing board, then that information ought to be part of an exhibit because the public ought to be keenly aware of what transpired within the entire continuum. If we're not involved in that discussion, then it wouldn't be an exhibit. But once we receive it, then it should be a part of the record.
Can I make a comment?
Go ahead.
Okay, so what I would, my opinion here is that if Mohan disagrees with this being heard on consent, because that is not attached, then that's how we should approach this, and we should take it off consent. Because if there's an issue, then that's how it should be handled. And it sounds like number 18 is referring to an attachment that is not here. And if you're uncomfortable with it not being attached as Exhibit 3, then this really should not be heard this way is my recommendation.
That's not my, I'm not uncomfortable at all. What I'm saying is she's referring to an Exhibit 3, which was not attached. I thought what she was referring to was this email, but we can put on the record, there was a reference in her declaration to Exhibit 3 that was not attached. And what it is, it's a notice of the ex parte.
Madam Chair.
That was
can I add
approved,
one,
that's all.
please? So then I would just
And then
add
we
to
can just move forward
Makai's
with that.
point, I think just the mere fact that the communication was made, if that needs to be public knowledge, fine, and that needs to be entered as an exhibit, sure, if that makes everybody happy to comply, then that is fair, because that way, right now, on the record, there's no date of when the communication or the attachments were sent. Perhaps if you really want that to be public knowledge,
Right.
then that's fair. So I think we've got a couple of issues here. Do you not want to proceed because of that point 18 attachment is not there? And then number 2, if you want a communication to be made public record on this day that we received these documents, then we can enter that, is kind of at least my assessment from what I've heard so far. I know there's different
It's the
opinions on
easier
that.
path. It's the easier, quicker path versus I don't think you're wanting to pull it off.
No, no,
consent.
that's not at all. She referred to an Exhibit 3 that was not marked in the petition that they gave us. They only marked 1 and 2. So we can just put for the record that in her declaration, Ms. Say referred to an Exhibit 3 that was not provided. What she was referring to was the ex parte that was granted on December 19th.
So that would be under number 2, her
And that is on
declaration.
fine already. That's on fine already, and we can leave it at that,
We
That's-
made it on the record, so we're.
Yeah, we got it on the record, that's all, yeah.
Okay,
Because if somebody's reading her declaration, looking at Exhibit 3, and then looking where is Exhibit 3, she won't find it, that's all.
well, she'll find the proposed findings and decisions because that is marked as number 3.
That's not.
So it's almost like a 2A. You
Well,
know,
What,
Well, he's satisfied now. So
Yeah.
we're satisfied.
it's
and I
on the
think that's
record.
all.
We've discussed it. We recognize what it is. The clerk has helped us in that regard. So we're okay to proceed. Correct? It's on the record. Okay?
And I would just add that the documentation will be uploaded as an, right. Just for clarity, because again, anyway, I'm not gonna get off.
No,
into
it is
a
already on
long
file because I
document.
went to find to look for it. I did find the notice because I was trying to find when was the ex parte granted. So that's where I found it,
Yeah. Yeah, I did grant it. Yes. All right. Let's go forward then. We recognize the fact that that document that she's referring to is on the record. We've discussed it. Now we can go forward, correct, Mohan?
Yeah.
Okay. Everybody happy with that? Okay. All right. So we have, as mentioned before, the Exhibit 1 is the stipulation. Number 2, the declaration. Number 3, the proposed findings. And then there will be I guess like a caveat then of the fact that there is also that other document that was discussed publicly at the hearing. Correct? Are you all right with that, Alteresa?
Yes, Madam Chair.
Okay.
The declaration indicates the name of what Exhibit 3 should be. And again, it is already on the district's website. As noted, it is not called Exhibit 3, but it is.
Part of
what-
it.
It is noted in the record.
Okay, all right. All right, I think we're done with that subject. We can go on to any deliberation regarding this this case. Did anybody want to begin?
I was going to point out, I think in the Exhibit 3 that you marked on the proposed finding and decision, they said this is a petition for ex parte emergency and short variance AOC. So I think we should remove this petition we are hearing is just for the short variance and AOC because the ex parte was already heard. So I think we should remove the ex parte and emergency in the finding and decision document because that's not
What page are you on?
on the first page of the proposed finding and decision document, Exhibit 3.
Okay,
Because it says ex parte emergency short variant AOC were heard on this date. That's not the case. The ex parte was heard on December 19th. So that's done.
okay.
We
Do you
just
want
need to remove the ex parte emergency and emergency from that.
Do we normally remove the notification of the ex parte? Do we normally remove notification on the document that there was an ex parte?
That's not normally on our proposed finding because the finding for the ex parte and emergency was already completed. I just think that they inadvertently left it in there. I believe it's typographical
All
error
right, okay.
as Mr.
So we can take out the sentence and start at hearing board's consent calendar?
No.
Where do you want to start this?
No.
So the petition, we removed the.
I think just in the first line,
Yeah,
right?
yeah, in the
Ex
first
parte
line.
Emergency and emergency, we just remove those two words, that's all. We keep the short variance in AOC.
All right, okay, so we're gonna start this petition with the words short variance and alternative operating conditions.
So
Is
we
that
start
right?
with the petition for the short variance and AOC were heard on the hearing of consent calendar on January 11th. But
Strike the words ex parte,
yes,
emergency,
strike out the word.
emergency, and.
Correct. Yes,
Mm-hmm, mm-hmm,
strike that out.
okay. So noted and so moved. We done with that part? We done with
Okay,
that part?
Yeah, and so, yes, just for some background, they were scheduled to do a source test on December 15th, but unfortunately prior to that, they found that they had to turn around, they did all the repairs, but the CO boiler was not operating, there was a breakdown. The outlet bulletins had restricted gas flow. So they were not producing enough steam to do the test, so actually to run the other processes also. So, but in Ms. Valerie's declaration, it indicates that they have now repaired the CO boiler, so everything's up and running. Unfortunately, they cannot do the test because there's only one source coming in, and they scheduled it now for February 13 and 14. So they're not in, so they're still out of compliance
Mhm.
with the source test date. They were supposed to do the test, but otherwise, they are operating as normally they would. So,
Yes, I would agree with everything that you have just said, Mr. Balagopalan. I know that there has been various problems in the past and hopefully they're getting everything ready for that future test. So I'm just I'm in agreement with you. I just want to make sure that they understand the fact that it's got to be, they've got to come into compliance, and it's not a good thing that they're out of compliance, being such a large facility. Any other comments? Okay. All right. So we can go ahead and go forward with this. Are there any comments from the public that you see, Madam Clerk?
Madam Chair, there are no members of the public on Zoom with their hands raised.
Okay. Anybody in the, okay, nobody in the auditorium who wants to make a comment. So with that, we can go ahead and go for the findings. Did you want to go ahead and start that, Mr. Bullock, upon?
Doing the final on the motion.
Yeah,
Just want to be clear.
right.
Of both. Okay, so, and I think the finding facts, we have to make two findings, one for the variance and one for the AOC.
Yes.
And I must, it is one of the few companies that, oh, I'm sorry. This is one of the few companies that actually, Title V facility that does AOC at the same time, so that's, because as we know, the AOC, variance is not recognized by EPA, AOC is, so.
You're right.
And so the petitioner, so they've laid out quite well the findings of fact, and I'll just go through, highlight what they have indicated. They'll be in violation of Rule 1105E2A that requires them to do the annual compliance testing, which was supposed to occur by the end of the last year. And due to the reasons cited earlier, that did not happen. So they're in violation of the permit condition D29 and D20, 29.3 and D29.4. So again, and so the non-compliance is beyond the reasonable control. They were all scheduled to test it, and then the CO boiler did not cooperate, so they had to, it was unexpected, so it's beyond the control. And also because they have only one, apparently there's only, I didn't realize there's only one company that can do the source test for the FCCU. So they're at their mercy. So it's now scheduled for February 13 and 14. The closing and taking would be without a corresponding benefit, air contaminant. They're operating normally, so there shouldn't be any increase in emission. And so there's no reason not to provide them with relief. And they have really, whether they have given any consideration curtailing operation, really everything is operating. There's no need to curtail operation because there's no anticipated excess emission. They're operating as normal as they allowed by under the permit. So, and during the period of the variance, there's no excess emissions to monitor or report. And so they meet all the 6 findings for the variance, and I believe we can make the motion to do the grant the short variance. And I'll do the AOC, which is very similar separately. And so I'll go through the motion. I'll go through the motion to make the motion. How's that? For the,
Of which we have to have 3, the AOC.
After that, yeah, we'll have to do the AOC separate. But in this case, so in the matter of Torrance Refining Company, LLC, case number 6060-20, I move that we grant a short variance, commencing, however, from December 19, because that's when the ex parte was granted. And since it's for 90 days and ending on March 18, 2024, from the following rules in subsection, and I think they laid it out quite well. Let me just highlight it. And it's 203B, 2004 F1, 3002 C1, and that's as pertaining to permit condition D29.3, 29.4, 1105.1 E2A and E2E, and the administrative permit condition E.8. So those are the conditions that they need relief from. And it's for the equipment that is located at 3700 West 190th Street in Torrance. And it's for the equipment that is listed on the in the petition. It's for the FCCU and the ESPs. So the the FCCU regenerated the CO boiler, the SCR system, the 2 ESPs, 219 and 217, as noted in the petition. The condition as set forth in the proposed finding and decision document for the variance, and there will be no excess emission anticipated during this period. With that, I conclude my motion.
Second.
Thank you. Thank you, Mr. Ali. Any discussion on the motion? I just want to put on the record that when I saw this originally, my first concern was, are there going to be any emissions? And the way that, exactly what you said, Mr. Palagopalan, they laid it out very clearly, what the problem was and that it was not due to something that they had done. It was an unexpected situation. So that's the reason why I originally granted the emergency ex parte. So with that, we have a motion and a second, and we, no other comments. So Mr. Ali, how do you vote?
Aye.
Dr. Abraham?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
Aye.
And I also vote aye. So that's unanimous. And we can go now to the AOC.
Yeah, and, okay, I will. I don't think we need to discuss further, all the findings they made and there are some other requisite finding for the AOC. However, because there's no excess emission, they don't need to get a RTC. But the other finding is they're not in violation of any NESHAP or NSPS. So that's the other finding that's been made. So there's no additional requirement. And I think they've laid out quite well the finding of facts in the proposed condition for meeting the AOC. So, I'll go in the matter, make the motion that in the matter of Exxon Torrance Refinery Cup LLC case number 6060-20, I move that we grant an AOC commencing again from December 19, 2023 and continuing through March 18, 2024 for the rules and sections and for the equipment that was previously stated, and I don't need to repeat myself. The conditions are as stated in the proposed finding and decision document for the AOC. And there's, again, no excess emission during this period. And
Okay.
with that, I conclude my
Second.
motion.
Okay, was that your
Second.
motion? That was your motion?
Yes.
And we
Ali
have a
seconds.
second,
Ali
okay.
seconds.
Any discussion on the motion? Mr. Pearman?
My only comment was if they were in person before us and gave us these stipulated conditions, don't we normally just approve the findings and not have two separate votes? I was just curious if that's what we do in person and why we did separately because they're not in person.
It's similar to the, when we bifurcate a case for a good cause and then for the actual 6 findings. And in this case, the AOC is separate. It's a separate document. It's a separate request. There are specific findings. You have to have 3 specific issues that address the AOC, so it does need to be different. Did you have a comment? Mr. Roper?
Actually, we did do separate, even when they're in
Once upon a
here
time.
before us, before AOC, we did always did 2 motions, one for, yeah, I liked what you did, actually combine them both, and I guess I could have done that, both the variance and the AOC, which I think you did in one case, which, so you don't have to go through, but I know we had done separately, even when they're here. Okay.
Yeah, and if it's for me anyway, if it was a small facility, I don't think I would have pause that, we would go ahead and combine them. But when it's a facility like this, and the AOC, I think is also for the sake of the EPA, and it's EPA's stringent requirements that they have. I mean, they oversee everything that we do, basically. So I just want to make sure that, especially a facility, I don't know why I'm having trouble with that word, facility, to dot all the i's and cross all the t's. And I think we have in this case. So
Madam
that's-
Chair.
That's why.
Just for clarity, to Mr. Pearman's point, both the motions could have been amalgamated. They didn't need to be bifurcated. He's simply saying we could have easily laid a motion on the table to include them all. There's no requirement to bifurcate the motion. I've not read that anywhere. So I just want to make that clear for the record.
Thank you,
That's
Mr.
to
Ali.
his point, that's what he was specifically asking, because he did it.
Any other comments?
No.
Okay, all right. So with that, we have the motion and we have the second. We've discussed it. Is there any other comments? Or are there any other comments? Okay. All right, with that, we can take the vote. Mr. Ali,
Aye.
Dr. Abraham,
Aye.
Mr. Pearman,
Aye.
Mr. Balagopalan,
Aye.
and I also vote aye. Okay, so the matter of Torrance is therefore completed, and we will go on to our next item, which is Colton Power. This is also on consent. And we will mark our exhibits. All right, the stipulation to place the matter on consent is 1. The declaration of Joseph Shepherd, number 2. We have the proposed findings and decision. That would be number 3. Well, then we have an HB1, which is dated on the top as January 9th. And it is a discussion online between Mr. Balakopoulon and the district, as well as the comments coming in from Colton, I believe. So in that matter, that will be HB1.
Can I add a comment on that HB1?
Go
I
ahead.
did make an error in the language. It should have been as amended on November 3rd, 2023. I had listed as 2003. So that should be corrected to reflect that. It should be November
Okay.
2023.
Okay, and that's on page.
That was the second page, I think, the proposed change. I had a proposed change of condition 5 to include that language in lieu of the above mentioned requirements. It's almost to the bottom of page 2.
Yeah, just for the record, the email is dated January 9th, 2024, at 3:41 PM.
Right.
Mr. Balakapalan to the clerk of the board.
Okay. Yeah.
And you got that, Madam Clerk, the correction.
Okay.
Yes, I do. On HB1, on the second page, near the bottom, the date, November 3rd, says 2020, says 2003. It should say 2023. So I do have that correction.
Thank you.
Okay. So noted. Okay, anything else on that HB1, Mr. Balakopoulon?
No.
All right.
I could say the reason I added that condition is because it's similar to again, the governing board changed the rule, so they didn't have to do all the things that's listed in condition number 5. They could do in what I mentioned in lieu of, it is in the rule. And it was the same condition I had proposed for 2 other, one facility, and then there was incorporated in the last Colton Power by the staff from AQMD, that same language. So it was just missing on this one. And that's why I included it.
Yeah, good catch. Okay, with that, we can go into any deliberation on this item, on this case. Anybody want to begin that? Okay, we've had Colton in front of us before. I think it's a matter of they are trying to come into compliance as soon as possible. They have had some difficulty there, and I believe we saw the 2 members of their company come before us. So I don't have a problem with this at all. I think they're doing their due diligence. I think they're doing their best to come into compliance per the declaration of Mr. Shepherd. So I believe that we can make the findings for this matter.
Yeah,
And this is also go ahead.
No, specifically, it's this is again a separate, the Colton Power, there's a different facility, a different location, but in the same city of Colton, and they supply power to the city of Colton. And it's the same type of equipment, gas turbine. They're having some problems with the turbine, and so they were not able to complete the annual ammonia slip test by the deadline of the 31st, 2023. So they have requesting a short variance. So they didn't indicate as whether they have what the extent of the repairs or what the problem is. They just know they couldn't run up to full power, and so they shut it down. So when they open it and they see what maybe the blades have got liberated, what the damage is, whatever. But in the previous facility, they had some spare and the blades that it could easily replace it. So hopefully that's the situation here. They can repair it and conduct the source test before the deadline and they're asking relief until March 30th. However, because the expire date, I looked at the expire date, it didn't say January 1, it says December 31st. So for the 30 days, it'll be till March 29th, is or March 30th, so we are within that, 90 days, because the short variance is for 90 days. So we'll have to, whoever makes a motion will be from December 31st to March 29th, 2024. So we're within the 90-day time frame. Other than that, I think the conditions that they proposed, is similar to what we had approved before, and just monitoring and notification, basically, when they're going to do the test.
We had a lot of them coming through here, flying through here at the end of the year, and there were, I can't remember how many ex partes I had on my desk that I needed to look through, read their situation, and then also whether I was going to go ahead and grant them or not. And I don't know why everybody waited till the very last few days, but they did. And in this case, as Mr. Balagopalan mentioned, I think they had a situation that they really couldn't avoid at all. And if they are able to get the parts from the other equipment that they have, and get it up and running before the 31st, my hat's off to them. Otherwise, they may have a problem finding those parts before that date, so that they can go ahead and run the ammonia slip test. So, but at this point in time, with everything that we have been given, I think that they are on the path to be able to meet the findings and go ahead and we can grant the short variance. Any other comments?
And their source test is scheduled for January 9th, and so the variance is until March 29th. So they got plenty of time to hopefully repair and do the source test.
Yeah, hopefully, yes. Okay, with that, any other comments? All right, Mr. Balakofalan, did you want to go ahead and make the motion?
Okay, so I'll just briefly go through the.
Excuse me, Madam Chair, Mr. Palakapalan, you stated that the ex parte was for December. What day did you say?
31st,
And if you now 90 days out, it would be.
March 29th. It's not, March 29th. Because it's a leap year, February is 29 days, so I counted it, so.
Okay, I just wanted to, I'm just figuring out the math. Okay, I'm thinking.
Right. So from January 1st, the previous one, we did it, it was to March 30th, was fine, that was the 90 days, so.
Got it. Appreciate it.
That leap year is messing everybody up. Okay, go ahead.
So again, they are in violation of a permit condition, but because they are unable to test it, the unit D15 by the end of the year. So that, so they do need relief, and so they'll be in violation of Rule 1134. E2C Romanet, now I figured out what the term is, 3, and 203B, 2004 F1, 3002C1, and specifically condition in section D, condition 28.1. So this again is beyond, the non-compliance is beyond the control, reasonable control, because they've also had to do the test, and then they found that they couldn't get full power for the natural gas turbine. They did some troubleshooting and remote testing and so forth. It didn't work. So they need to, they have then taken it out of service. It's not operating. There's no excess emission. Hopefully they will repair it and run it. And then because they need to get at normal conditions, so before they can do the testing, so that, so requiring compliance would be unreasonable closing, because they, unreasonable taking of property and the closing and elimination of a lawful business, because at this point they're not running it, and there's no excess emissions. There's really there's no need to curtail. I mean, they already curtail operation because they're not running gas turbine, so there are no excess emission to the period, and they don't have to do any monitoring, except for the condition number 5, which requires them to show that, that there's no emissions been emitted. And so I think for all those reasons, we can make the 6 findings, and I can go ahead and make the motion for the short variance, if that's okay.
Yeah, I just wanted to make the comment that they really did try everything that they possibly could, knowing that they were running up to the date and that they would definitely be out of compliance, which I'm sure they didn't want to happen. But again, since they did their due diligence and did try to find a solution, but could not in that short amount of time. So I also agree with Mr. Balagopalan's comments. Anything else? Okay, Mr. Balagopalan?
Okay, just a second, let me get there. So in the matter of Colton Power LP, case number 6167-4, I move that we grant a short variance commencing December 31st and continuing through March 29th from the following rules and subsection. So it's rule, just give me a minute and I'll get that. 1134 E2C Romanet 3, and then the 203B 2004 F1 3002 C1, and also permit condition 28.1 in section D of the facility permit for the equipment that is located in 671 Cooley Drive in Colton, and it's for the equipment that is the simple cycle gas turbine identified as reclaimed device D15 in the facility permit. And the conditions are as proposed in the, as laid out in the proposed finding and decision document, with the insertion of the condition I had to condition number 5, and with the correction that we noted earlier, this should be 2023 to condition number 5. And there will be no excess emission because the unit is not operating at this time. That I conclude my motion.
Second.
Okay, so moved and second. Any other discussion? All right, Mr. Ali, how do you vote?
Aye.
Dr. Abraham?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
Aye.
And I also vote aye, so it's unanimous that we go ahead and grant the short variance for Colton Power LP Century, also located at the facility number 1822561. Okay, with that, I believe that we don't have any other matters before us. This matter is
Yeah,
closed as well. Mr. Ali.
Before we adjourn, I just wanted to make a comment under board member comments
Yes, go ahead.
pursuant to California Government Code 54954.2. So, Mr. Pearman, some months past, you were working on a host of modifications. Do we have a timeline with respect to those matters?
Yeah, I'm working on bringing it to the board. We had to wait for 2 inputs from outside counsel, working with Adrian, and I think her illness slowed it down, but I spoke to Dale maybe, if not this week, Friday, and so he gave me his final input on those 2 points. So I'll be putting it together. Within the next week, I'll get it to the clerk and the chair to agendize it.
Okay, and then we can just add it to, so that we don't have to have a general body meeting, we can add it to an agenda,
That's the plan.
and then we can proceed forward. Okay,
That's
no
the
problem.
plan.
Thank you. Thank you very kindly.
And
Madam Chair.
also, please, it should be noted also that our clerk of the board gave the governing board in other words, there's a placeholder for all of our comments and what we are asking, any changes that we are asking, everything that Mr. Pearman put together previously. So we have a placeholder where that can be put before the governing board, which I think was a very insightful thing to do ahead of time. Any other comments? Well, Mr. Ball?
No, I know we haven't heard anything more on Baker. I thought it was coming back to us.
Baker? Oh, yes. Oh, yes. Oh, yes.
You know,
It's,
so I heard anything when,
we haven't, and as far as comments that would be coming from Mr. Larson, our attorney, because everything that is decided with Baker's attorneys and AQMD's attorneys, they do contact Mr. Larson. And then he does that information normally in closed session. But they haven't, to my knowledge, there hasn't been any movement. The last I had heard was that Baker was going to go to the district and give them some proposals that would ultimately come before us to make the decision based on the fact that we are the body that closed them down. And it was here that everything stopped. So they have to eventually come back to us.
Just that Mr. Lawson thought it would come before it last year.
Yeah, well, they have new attorneys. Baker has new attorneys. And I think that has a lot to do with the fact that they needed to get up to speed on how they wanted to approach this, which is entirely different, as I have heard, that it's very much different than what the previous attorneys have proposed. So that being said, I think that's a good reason for them to take a little bit longer than, and if they want to get it right, I'd rather that we take a little bit longer. Or they take a little bit longer, because this is something that is significant, not only to that company, but also to the people who live around that vicinity, around that facility. So, anything else? Okay, Mr. Ali, anything else? Okay.
Good to go.
With that, thank you, Mr. Balgobin, for your comments. Thank all of you for your comments and for being here today. I know it was a little difficult for some of us, but yeah, thank you very much for making the effort. Okay, with that, we are adjourned. Thank you very much.